Do any jurors need the restroom at this time before continuing further? Okay. State.
Ladies and gentlemen, counsel, I want to thank you all for all the attention you've given us throughout this long trial. I know that sitting and paying attention throughout this trial has been exhausting. It's been a lot of work. And the more difficult work, believe it or not, is about to start when this case is turned over for your deliberations. Now, one of the things we heard a lot of words used to describe the case. I think the word ridiculous was used at least 6 times. The word fiction was used a couple of times. Preposterous was used. You know, this case is important. Mr. Rodgers is on trial for his life. And this case is about more than just catchy buzzwords. It's about evidence. You don't get to pick and choose when you're sitting at this table. You don't get to pick and choose the evidence you want to believe and what you don't want to believe. You don't get to cherry pick the witnesses. You take them how they come to you. For example, Taylor Showmaker is a liar, except when she's saying good things about Mr. Rodgers. Curtis Wright is a liar, except when he says he hit Teresa Sievers with a hammer. Interesting point that was not discussed. Second-degree murder in Missouri, that's 15 to 20. I'm good with that. Those were his words. Jimmy Ray Rodgers. He said that. And he said that to Lieutenants Levitt and Downs. Not Taylor Shoemaker, not Curtis Wayne Wright. Those were his words. Okay, so I'm going to start out first by addressing what I can address from the defense closing, and then I have some things I want to discuss with you in the PowerPoint. One of the other phrases that was used, other than preposterous and ridiculous and all the other words, was, well, there's no evidence other than. There's no evidence other than. You probably heard that on more than once just now. And again, as a jury, ultimately it's going to be your decision to decide what evidence is credible and what evidence is not credible. Okay? And that's your job to do that. A lot of things in this case, as counsel said, don't pass the smell test. At the end of the day, a woman is dead, a mother is dead, a doctor is dead, a human being is dead, a wife is dead. For no good reason. But this theory that you heard, that somehow Mr. Wright didn't participate in a conspiracy to kill Teresa Sievers, it's one of those things that doesn't add up. How did he know how to get into the house? How did he know Mr. Sievers and the family wouldn't be home? How did he know about Mr. Sievers' mom feeding the dogs? How did he know Dr. Sievers would be home alone? How did he know to be here on Sunday, June 28th, 2015? How did he know that? How did he know? The evidence says, not speculation, not cherry picking. The evidence says he knows because he was told by Mark Sievers. The evidence tells you that the two of them had burner phones that they were using to communicate. Even if you don't believe what Mr. Wright told you about the burner phones, You've got coded messages in evidence. Check other. Check other? This is not, the crime of the century here, but for the fact that Dr. Sievers is gone. These guys weren't the smartest co-conspirators. So this is something that Mr. Wright did by himself, right? You saw the pictures that came into evidence when Ms. Ross did the direct exam of Dr. Coyne. She had injuries all the way around her head, 360 degrees. Nose, forehead, top of the head, side of the head, side of the head, back of the head. Defensive wounds. How does that happen with one hammer? How does that happen? It doesn't happen with one hammer. It happens with two hammers. Dr. Coyne didn't say this was one person, one hammer. Could have been. Could have been more than one person with more than one hammer. That's what he said. You rely on the testimony that you heard from the stand. It's your collective memory that matters the most. This wasn't musing. This wasn't rambling. Again, these are all catchy buzz phrases. This is a murder case. This is serious. So, what does this person who Dr. Sievers allegedly was having an affair with, according to Mark Sievers, the other killer, have to do with this case? What does it have to do with this case? Nothing. That's a distraction. You have to focus on the evidence and the law that will be given to you at the end of the trial. Another distraction is this blood spatter. And again, you have pictures. You'll see pictures. You'll see blood spatter on the refrigerator, on the floor. And yes, blood spatter happens when you take an object and you hit blood. Okay? If you ever spilled something on your counter, if you ever slapped your hand in a pool of water, you hit it, yes, spatter. But blood spatter doesn't happen when you hit somebody's hairy scalp. Doesn't happen the first time. Doesn't happen the second time. What happens is you get a hammer full of hair. You can look at the photos yourself. What does it mean? What, Dr. Sievers isn't dead? Because the blood spatter doesn't fit whatever their theory is? Does it mean that? Does it mean that Mr. Rodgers didn't do it? That Mr. Wright didn't do it? He did it. What does it mean? It means nothing. You hit somebody in the head who has a lot of hair, you get hair on the hammer. That's what you get. And that's what happened in this case. You heard every witness who testified about the scene said Dr. Sievers died where she lay. She wasn't killed somewhere else and then brought to the scene. She wasn't moved somewhere else in the house after she was killed. No, there's evidence.
Overruled. It's argument.
during her first opening, Ms. Ross asked you to apply logic, reason, and common sense in evaluating the evidence in this case and evaluating the law that you're going to be given by the court. And you have to apply common sense, you have to apply logic, you have to apply reason. But there really isn't a logical reason for murder. There's no logical reason. What logical reason could a person have for killing an unarmed, lonely woman in her own house by herself at night, who poses no threat to anyone? There is no logic to that, unless you're doing it for money, unless you want to get paid for doing it. We talked about the rental car, and again, not to beat the dead horse, Mr. Wright, if you want to believe Mr. Wright, and it's up to you to decide whether you want to believe him or not. You can believe him, you can disbelieve him. You can believe part of what he said and disbelieve part of what he said. You take him how you get him. He says he rented the car, he didn't think he'd be caught. And how do you go anywhere to get something to eat, to get gas for the car, to even drive on a highway nowadays without being seen on a camera? How do you do that? If you drive into town and you don't think anybody who's here is going to know that you're here, are you concerned about cameras? Probably not. Oh, and Mr. Wright was driving. That's the evidence that you've seen. Mr. Wright was driving the vehicle. He also told you he and Mr. Rodgers shared the driving. He didn't tell you he hired Mr. Rodgers to drive for him. And you've seen evidence to the contrary. I'm going to show it to you again before you go. Mr. Rodgers was not a chauffeur. And if he was, he did that for free too. Right? Now, you've heard a couple of different descriptions of what counsel says was done with the Garmin unit. And again, you've got to rely on your evidence. Yes, Mr. Wright, Mr. Curtis Wayne Wright, plugged the Garmin unit into the vehicle that he rented so he could navigate to Florida. But he didn't connect it to Mr. Rodgers' phone. Mr. Rodgers did. Jimmy Ray Rodgers 90 at gmail.com. That's in the Garmin records. Rodgers did that. Not Wright. And again, that's if you want to believe what Mr. Wright told you. Because again, you've got to take the good with the bad. You just can't believe the good parts that he says that helps the defense theory of the case and completely disbelieve the bad parts for the defense. You take the good with the bad. So Mr. Rodgers is down here. Well, he might have been down here. He might not have been down here. You got to decide based on the evidence. I submit to you, Mr. Rodgers came to Florida. He rode 2,400 miles round trip in a vehicle without a hotel room. Didn't have anywhere to sleep or spend a night. Is that reasonable? This was a planned trip to come into town, kill Dr. Sievers, and disappear out of town. That's what this was. That's what it was. That's the simple answer to the question. So the plan to stage the burglary, and again, if you choose to believe Mr. Wright, they get to the home at 6 o'clock in the morning. He knows that Mr. Sievers' mother is expected at the house to feed the pets. So if you burglarize the house, then what's going to happen? Police are going to come. So if you want to carry out your plan to kill Dr. Sievers, which he says this was a plan to kill Dr. Sievers, you can't tip anybody off that you've been in the house. It's not logical to kill somebody, but it's a reasonable explanation of what he did, if you believe him. And make no mistake, he's a killer too. The state's star witness in this case is not Mr. Wright. The star witness in this case is the evidence as a whole. This case is not about and has never been about one witness or about one piece of evidence. This is about the totality of the case. Testimony of Taylor Showmaker, testimony of Curtis Wainwright, testimony of Lieutenant Levitt, testimony of Lieutenant Downs, testimony of Mr. Conway, testimony from the FBI, testimony from the analyst at the sheriff's office, testimony from the crime scene technicians. You can take the case and break it down into little pieces, and I can guarantee you're going to find reasonable doubt in every little piece. But that's the opposite of what you're supposed to do.
Both sides approach for a moment. You ready? At the conclusion of the closing statements, I am going to read you instructions, which you will be allowed to take with you back to the jury room when you begin your deliberations. I will give you an instruction on reasonable doubt, and that is the instruction on the law that you are to follow. State.
So you look at all the evidence in the case, and you then review the law that the court will give you. And you make a decision about whether or not you are convinced beyond a reasonable doubt that the state has proven its case. That's what you do. You can exclude evidence if you don't believe it's reliable. You can exclude any or all of the testimony of a witness if you don't believe that testimony is credible. But you got to put it all together. Now, one of the things that was discussed earlier, was this notion that this frenzied rage plan by Mr. Wright. And again, if you believe Mr. Wright, if you choose to believe him, he told you he was caught by surprise. He misunderstood the time that Dr. Sievers was supposed to be arriving home. Okay? It's in the testimony. It's probably in your notes somewhere. He misunderstood the time. He's standing in the garage. He and Mr. Rodgers have suited up. They've got their blue murder suits on. They're duct taped, and they're ready to go. He's standing in the garage looking at the motorcycle. He's not sure where Mr. Rodgers is, but he knows he's in the house somewhere when the door starts going up. Why would he make that up? His testimony is far from perfect. Why isn't it? Why isn't his testimony perfect? Could have been. Why would he bring Mr. Rodgers into a murder for no reason? Oh, he wanted 25 years instead of life. Well, why not just get 25 years for talking about Mark Sievers? Why would he do that? Who is Mr. Rodgers? Who is he? Why is he so important? Why would he?
Sure.
And if everybody else is involved in this, why? When did they rehearse this plan?
Have both sides approach for a moment. You ready? We'll take a quick restroom break again. Let the jurors stretch their legs. Use the restroom if you need to. Please don't talk about the case among yourselves with anybody else or look up any of the people or places involved even at this point. We'll see you in a moment. Assistant State Attorneys are present. Defense is ready.
May we approach on one issue that
Sure.
is addressed?
And for the record, all four defense counsel are present and Mr. Rodgers. State's ready.
Yes.
Defense is ready. Bring them out. Please be seated. I'll ask our jurors again, did you follow my instructions? Not talk about the case among yourselves with anybody else or look up any of the people or places involved. Even if you did so inadvertently, now would be the time to raise your hand and let me know. For the record, no jurors lifted their hand. State.
Okay. Pick up where I left off. Skip a few things here. Let's talk a little bit about Taylor Showmaker. Okay. On the one hand, Ms. Showmaker says that Mr. Rodgers was paying the bills. She was living with him at his home. I think the defense counsel used the term meal ticket. But she would give all of that up for $400 a month, $4,800 a year. Do you believe that? And it was she who approached Downs. Yes, Downs and Levitt had been to the house investigating Mr. Rodgers when, by the way, he said he hadn't been to Florida and didn't know the Sievers. Something that has also been shown to be untrue.
Objection, Your Honor. Facts and evidence.
Overruled its argument that juries to rely on their own memory of the evidence.
I believe it was Downs and Levitt who said that Mr. Rodgers said he hadn't been to Florida, and I believe it was Downs who said he didn't know the Sievers. In any case, rely on your memory of what was said. So she tells the detectives that Mr. Rodgers told her what he did. And he killed that woman in Florida. He did it for $10,000, and he used a hammer. This happened in 2015. In 2016, she reaches out to Downs for witness protection. And the sheriff's office makes the funding available. So the sheriff's office didn't pay for her to testify against Mr. Rodgers. She did that on her own. She did that way before she got any money. And how did she know? How did she know about the hammer? She said when she testified that she asked if Mr. Rodgers had shot the woman because she didn't know. He said it was a hammer. So if she's lying about that, that's a lie. How does she know? She says he said he was doing it for $10,000. Mr. Wright says the same thing. If she's lying about the $10,000, how does she know? She knew because that's what he told her. That's how she knew. So this is not just about picking and choosing what you believe about Taylor Showmaker. Maybe he was a good father. Maybe he was good to her children. Maybe he did pay the bills and take her in and take care of her while she was pregnant. He did. But the evidence also says that he killed Dr. Sievers. Okay, so moving on to the prepared remarks. All right, so remember defense counsel during closing made reference to Mr. Wright's change in clothing? Well, Mr. Wright's not the only person who had a change in clothing. This is Mr. Rodgers, a snippet from the video of him entering the Bushnell shell, and you can't see the time at the bottom of the screen, but it's 2:54 a.m. You see these shoes? Black shoes. All right? See this t-shirt? Plain white t-shirt. There's a still photo of it. And again, these videos and evidence, so you'll get a chance to come out and watch the video all you want. Black Oxford shoes. See that? Oh, and remember how counsel said Mr. Wright wanted Mr. Rodgers to do the driving, right? This is video from the
Objection,
Bushnell.
It's a misstatement of what I said in my argument.
Overruled.
This is video from the pumps outside Bushnell. And you get this, you can watch the moving video when the white Elantra that's in evidence pulls in. Look who's driving. This is the driver's side of the vehicle. Here's the front of the vehicle. Look who's driving the vehicle. And you'll get to see, if you watch the video, you get to see who gets out on the passenger side of the vehicle. The car then gasses up and pulls into a parking space in front of the Bushnell shell. Look who's driving. Mr. Wright's driving. Mr. Wright's driving, not Mr. Rodgers. I'm sure Mr. Rodgers probably did some driving at some point, but Mr. Wright was driving the vehicle at 3 o'clock in the morning on the 29th. This is evidence right here. This is not opinion. This is not conjecture. This is not argument. This is evidence. Mr. Wright was driving the vehicle. So we also back up to the Walmart in Fort Myers. See these shoes here Mr. Rodgers are wearing? White sneakers with the white, was counsel objecting?
Yes, sir.
Yes.
Yes, sir. Yes, sir. Tell me when you're ready. Ready? Ma'am? Yes, ma'am, we can close that for you.
Okay, so this is a still photo from the video at the Walmart in Fort Myers that's in evidence. Okay, you see Mr. Rodgers walking in here with these sneakers on. If you play the video, you'll see him walk by a little white rim on the sneakers with a little design on the side of the sneakers. You also get to see those sneakers in Missouri later on. Those pictures went into evidence. Those black Oxfords from the Bushnell shell, I guess, is as good as mine. This is a snippet again of the video from the Walmart. Sneakers. Another snippet from the video. See the t-shirt Mr. Rodgers has on? See the little design on his arm? On his left arm in the picture as he walks by? This is the t-shirt he has on at the Bushnell shell. No design on the left arm. Watch it yourselves. Make the decision for yourselves. Different shirts, different shoes. So Mr. Wright wasn't the only person who changed his clothes. Different shoes. So defense counsel talked about the principles instruction. I have it up here. I'm going to discuss it with you briefly. The defendant has to have a conscious intent that the crime be committed. Conscious intent to commit a crime can come from something as simple as bringing a blue murder suit and duct tape to commit the crime. That's all you have to do to be a principal. Doing something or saying something which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to commit the crime. So even if you don't believe that Mr. Rodgers swung a hammer, I'm not saying you shouldn't believe that, you should, because the evidence says that, but you believe that he brought a murder suit to help Mr. Wright commit first-degree murder, he's still guilty. In fact, you don't even have to be a principal. You don't even have to be present when the crime is committed to be a principal. Talk a little bit about the independent act instruction. The issue here is whether Mr. Wright committed the crime independently of Mr. Rodgers. Whether or not it's an independent act of Mr. Wright. In order to find that the independent act applies, you have to find, for example, if you find the crime alleged was committed, the issue in this crime, first-degree murder, was it an independent act of a person other than Jimmy Ray Rodgers? An independent act occurs when a person other than Jimmy Ray Rodgers commits or attempts to commit a crime. The crime has to be one in which Jimmy Ray Rodgers did not intend to occur. Murder suits suggest otherwise. A hammer, duct tape suggests otherwise. In which Jimmy Ray Rodgers did not participate and which was outside and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by Jimmy Ray Rodgers. Okay? And you're going to get to hear this instruction later on from the court as well. The court is the ultimate authority on the law. If you find that Mr. Wright committed this, it was an independent act, then you should find Mr. Rodgers not guilty. How did the blue suits get to Florida? Mr. Wright doesn't work at Doe Run. You heard Mr. Conway tell you that. How did the blue suits get here? The FBI says these blue fibers that were in the white Elantra that were on Dr. Sievers came from that blue suit or another one just like it. How those blue fibers get on Dr. Sievers? How did they get on the suit? How did they get off the suit, rather, onto Dr. Sievers? They got there because Mr. Rodgers brought the suit from Missouri. Thank you. So, ladies and gentlemen, why is Mr. Rodgers guilty? He's guilty because he told Downs and Levitt he had not been to Florida, which is untrue. He's guilty because he told his then girlfriend, Taylor Showmaker, that he killed Dr. Sievers with a hammer for $10,000. Mr. Rodgers is guilty because he destroyed evidence, the blue suit and the cell phone. He's guilty because on that evidence, specifically the blue suit that was thrown out the window on the road from Doe Run, had his hair on it. And yes, would have been a good idea to put a cell phone in a battery shredder in Doe Run. Problem is, you got to get suited up to get in there. The shredding operations are inside a contamination zone. You heard that from Mr. Conway. Easier said than done. Mr. Rodgers is guilty because he was seen with the blue suits, the hammer, the gloves, the duct tape, and the cooler. Mr. Rodgers is guilty because he's trained in contamination procedures. And you heard Mr. Wright, if you want to believe Mr. Wright, explain to you how they suited up, duct taped up for the crime, which just happened to be the way Mr. Conway explained that some of the workers at Doe Run also suit up. Mr. Rodgers is guilty because when he talked to detectives, and he told the detectives in Missouri, second-degree murder, punishable by 15 to 20. I'm good with that. Those were his words. Mr. Rodgers is guilty because, even though he, as counsel noted, he told people he was going to Florida, he told them he was going for graduation, for his brother's graduation. There was no graduation in June. There was no graduation. He was going to Florida to commit murder. The graduation story was a cover story. I need time off to go to Florida. I got to give my boss a reason, so I'll make one up. It's cover. Mr. Rodgers is guilty because his phone is on the cell phone towers in Florida. And even though you heard the testimony, the cell phone towers are not pinpoint accurate, the one inescapable fact is that Mr. Rodgers' cell phone was in Florida, in Bonita Springs. Mr. Rodgers is guilty because his co-defendant, Mr. Wright. And if you're angry with the state because Mr. Wright got a deal, you're going to hear an instruction that your decision in this case shouldn't be made because you're angry with anyone. You can be angry with the state, but your decision on the evidence, on the law in this case, has to be made by that alone. Mr. Wright says that there was an agreement between him and Mr. Rodgers to kill Dr. Sievers. Mr. Rodgers was supposed to get paid $10,000. How did Taylor Showmaker know that? Mr. Rodgers agreed to come down to Florida and help Mr. Wright kill Dr. Sievers. And he brought the blue suits and the other items needed to effect the killing. Mr. Wright says Mr. Rodgers picked up a hammer in the garage and joked about it. It was her destiny. He doesn't know what happened to the hammer, and he thought Mr. Rodgers had gotten rid of his blue suit. He says they went to a truck stop. Mr. Wright went to one garbage can to get rid of his things, and Mr. Rodgers went somewhere else. He thought the blue suit was gone. Why isn't his testimony perfect? Why doesn't he say, you know what, he kept that blue suit, that's a blue suit over there? He didn't say it because he didn't see it. He didn't know what happened to the blue suit. Is he an evil, despicable person who did an evil and despicable thing? No excuses. Even if you want to decide this case, I'm going to throw down a gauntlet for you. Disregard the testimony of Wayne Wright. Throw it out. And make your decision based on the other evidence in the case, based on a defendant's admission. If you don't want to believe that a person who's getting a deal from the state can be credible under any circumstance, throw it out. Even without Mr. Wright's testimony, there's evidence beyond a reasonable doubt that Mr. Rodgers is guilty of murder. Throw it out. Because even if you throw it out, you've got physical evidence, you've got cell phone evidence, you've got video evidence, you've got fiber evidence, you've got coveralls, you've got evidence of destruction of evidence, you got statements to Downs and Lebed, statements to Taylor Showmaker, and untrue statements to Jeff Conway, and an admission to Taylor Showmaker. That's without Curtis Wainwright. So, ladies and gentlemen, I submit to you that Jimmy Ray Rodgers is guilty of first-degree murder. And you're going to hear in the instruction that he can be guilty the way he's charged, he's charged on one of two different theories. Either first-degree premeditated murder, you'll hear the instruction on the elements of that, or first-degree felony murder. And the felony murder is based on the accusation of him committing a burglary and a killing happening during the commission of the burglary. We've got two theories of first-degree murder. He's also guilty of conspiracy because he planned with Curtis Wainwright to come down to Florida and kill Dr. Sievers. The evidence has shown you that. And finally, he's guilty of burglary. Dr. Sievers didn't give Mr. Rodgers permission to come into the house. And Mr. Wright, even though he had permission from Mr. Sievers for him to enter, he can't give somebody else permission to enter somebody else's house. Mr. Rodgers is guilty of burglary. After you get your jury instructions, the court's going to give you a verdict form, and the verdict form will have all three counts on it. And not only will you have the accused offenses on the verdict form, but you'll also have the lesser includeds, and the court will also instruct you on what the lesser includeds are and the elements of the lesser includeds. After you consider the law in this case, and you consider all of the evidence that you heard in this case, your verdict will fit first-degree murder and conspiracy and burglary. I thank you for your time. I thank you for your attention. And I thank you for your verdict.
Okay. It's 5:40, and I remember when we first picked our jury, I told you we might go late on the first night of deliberations. However, deliberations and their length is entirely up to you. And since it is kind of late, the instructions, I'll tell you, will take probably about 45 minutes for me to read them to you. And I am happy to read them to you and let you begin tonight if that's what you would like to do. I'll order you some food and you can start tonight. If you don't finish tonight, you come back tomorrow. Or I can read the instructions tomorrow morning and you can begin deliberating tomorrow morning. I'm going to let you guys go in the back and make that decision on your own. And then after you make your decision, just knock on the door. You can come on out and let me know what you all want to do. Please be seated. I think the only remaining issue is the proposed instruction on circumstantial evidence. I've given it a lot of thought, and I'm not going to give it, but in the abundance of caution, I'm going to put it in the case file in case it becomes an issue on appeal, if that happens. Yes, ma'am. Thank you. You'll have to order more pizza than normal. Yes. Okay. Please be seated. What would our jury like to do?
We'd like to go home and start tomorrow morning.
Okay. I'm going to instruct all of you again, still at this point, do not discuss the case among yourselves or with anybody else, or look up any of the people or places involved. We'll see you tomorrow morning at 9 o'clock. Yes, sir.
Will we be permitted to leave for lunch?
I will probably provide you lunch. If you want to bring your own food, by all means, I think some of you have brought food. Feel free to bring whatever you'd like. Again, just with the caveat that you have to tell the folks downstairs that you're one of my jurors. Otherwise, they will give you a really hard time. We'll see you all tomorrow morning. 9 o'clock. Please be seated. Anything further from the state at this time?
No, nothing further from the state.
From the defense? Okay. We'll see everybody tomorrow morning. 9 o'clock.